Welcome into the Cheeley Law Review. My name is Ben Burnett. My guest today is Gabby Gravel. Gabby, I want to talk to you about a settlement versus a trial. How do you evaluate what is right and what is best for your client?
So the ultimate goal when trying to get anybody recourse or justice from the court system is you'll want most of the compensation to go to the client. You want to keep as much in their pocket as you can, because even though money may not make you whole again, it's the only type of recourse in civil court. So most of the time, we will weigh the pros and cons of going to trial versus settlement based on expenses to the client, what it would cost to go to trial, how pre-litigation has played out. So we're looking at what's been offered, what hasn't been offered, how is the relationship between defense and plaintiff in the current state. And then you'll think about what is it going to cost to actually go to trial. So there's travel if it's out of town, there's witnesses that sometimes have to be paid if they're expert witnesses, there's different types of exhibits that may cost money to build, like if you're doing a major accident reconstruction. Sometimes I've seen law firms have somebody who works in movie sets actually build a piece of the accident and bring it into the courtroom, and that can cost a ton of money. But compared to what the case might be worth, that could be a drop in the bucket. So every single case is a completely different scenario that has to be assessed. And so no case is like the next. I do think that the most important thing is explaining that to your client, because most of us only know what trial might look like from movies and TV. And unless you actually sit through an entire one, it's hard to know what to expect, and you may think that a trial wouldn't cost anything, because that's kind of what my first inclination would be. You walk in, you present the facts, and then that should be it.
And you would be wrong.
Right, and that's a little surprising to most people. But keeping the client completely informed of that, especially from day one, just so expectations are reasonable and you know what's going on the entire time, is so important.
As you establish the differences, let's assume that most cases, in some way, shape, or form, attempt to mediate, either by force or by choice. That happens. How do you prepare a client for what could potentially be a jury trial and the stress that will be put up on your life and their lives?
So I think mediation is actually a very good precursor to litigation if you don't end up mediating. It gives you a chance to present both sides of the case. So a mediator is going to be somebody who is non-biased. They're not in cahoots with either side. And
they don't care.
They don't care. They really are there to try to help you come up with some sort of solution to keep you out of the courtroom. But they're going to hear your facts and the other side's facts for the very first time. And so that's like first your
litmus test.
And you're pitching it to a non-biased party. So the mediator might give you some sort of insight, like, hey, your case this is good what they're offering you, or they're not offering you what they should. This doesn't make any sense. And so you might get a little out of the mediator. You might not. It's important to also explain when there is an emotional level. So sometimes you're dealing with cases where nobody's been hurt and it's just
tragic death.
It could be a tragic death. It also could be a business dispute. A tragic death is going to be a lot more emotionally tolling on a person to actually go to the courtroom every day, hear about their loved one, hear about how they passed away, what they went through, the pain and suffering, and then all of that, having a bunch of strangers in a jury judge all of this just from one day of hearing it, when they may have been living this truth for years and they've been anxious and waiting for it. So that's also something we try to prepare people for. It is a lot to go through emotionally. It's a lot for a family. Sometimes you want to leave the courtroom and come back in for certain witnesses. We had a case last year where we really thought it was not appropriate for the family to have to hear about accident reconstruction, about what happened to their loved one in the last moments when they were in a lot of pain. So it really is a lot to think about, and when you're making that choice of, okay, do we want to really try to settle this out of the courtroom, or do we want to have our day in court? That's another thing. Having your day in court means something different to a lot of people, but I think For most, getting that vindication and just having a jury say, you were right the whole time. This is ridiculous. You were right the whole time. Getting that verdict means a lot to people. Even if it's not about the money for some people. It's having that this should not have happened and they were wrong and they should be punished and you were right. Sometimes that's enough, and that is closure for a lot of families.
Gabby, thank you for joining another episode of the Cheeley Law Review. Have a great day, everybody.